Rainwater ran off the cardboard boxes stacked along the curb. Sarah Mitchell stood motionless beneath the porch light, one grocery bag hanging from her hand while her suitcase rested beside her feet. She slid her house key into the front door. It stopped halfway. She tried again. Nothing. A bright silver deadbolt stared back at her. It was not hers. She looked up. The flower pot she had painted with her late husband 7 years earlier was gone. The welcome mat was different. The curtains inside the living room had changed. For one impossible moment, she wondered if she had walked to the wrong townhouse. Then she noticed the number, 214, the same number she had walked toward nearly every day for the last 7 years. Someone laughed inside. A television was playing. There were people living in her home. Sarah knocked. The door opened only a few inches. A young man looked confused. "Can I help you?" Sarah blinked. I live here." The man frowned. "No, ma'am. We signed the lease yesterday." Sarah felt the grocery bag slip from her fingers. Milk spilled across the porch. Apples rolled into the rain. Before she could say another word, a folded sheet of paper taped beside the door caught her eye. Across the top, in bold letters, were words that made her stomach drop. Order of eviction. She stared at it. She had never been to court. She had never received an eviction notice. She had never missed a rent payment. Yet somehow, according to that paper, she had already lost her home 3 days earlier. Sarah Mitchell left Columbus, Ohio, before sunrise. She was 42 years old, an elementary school teacher, quiet by nature, the kind of person who remembered every student's birthday and still mailed handwritten Christmas cards. Her husband, Daniel, had passed away 4 years earlier after a long battle with pancreatic cancer. They never had children. The townhouse on Maple Ridge Lane became the place where every memory still lived. Daniel's woodworking tools filled one corner of the garage. His fishing rods still leaned beside the basement stairs. His favorite coffee mug remained in the cabinet exactly where he had left it. The townhouse was not luxurious. 2 bedrooms, 1.5 bathrooms, a tiny fenced backyard, just over 1,100 square feet. But after 7 years, it felt more like home than any place Sarah had ever owned. Every month, on the 25th, she paid her rent electronically. $1,420. Always on time, never once late. She kept every receipt inside a blue accordion folder labeled simply Home. The owner of the property was Richard Coleman. He managed nearly 40 rental homes across Franklin County through a company called Coleman Property Group. Sarah rarely saw him. Most communication happened through email, occasionally through text messages. Whenever something broke, she filed a maintenance request. Someone usually came within a few days. Nothing about the relationship had ever seemed unusual until early September. One afternoon, Sarah received an email. The subject line read, "Important property update." Richard explained that property taxes had increased dramatically. Beginning the following month, rent would increase from $1,420 to $2,350 per month. Sarah read the number twice, then a third time. It had to be a mistake. Ohio law generally required notice before rent increases for month-to-month arrangements. But her lease still had several months remaining. The signed lease clearly fixed the rent through the end of March. She opened the document. Page 4, Section 8. The amount was there in black ink. Monthly rent, $1,420. No clause allowed a mid-lease increase. Sarah politely replied. She attached a scanned copy of the signed lease. She wrote only 2 sentences. "I believe this increase conflicts with our current lease agreement. Please let me know if this email was sent in error." Richard answered less than an hour later. "Pay the new amount by October 1st or vacate the property. No explanation. No apology. No discussion." Sarah felt uneasy. The next morning, she visited a local tenants' rights information center during her lunch break. A volunteer reviewed her lease. He shook his head. If this lease is still active, he can't simply invent a new rent amount. Sarah thanked him. She returned to school, feeling relieved. She believed the misunderstanding would eventually work itself out. She had no idea Richard Coleman had already made another decision, one that would leave her standing in the rain, locked out of the only home she had left. Sarah didn't sleep that night. A fellow teacher insisted she stay in the guest room of her apartment instead of paying for a hotel. She accepted, but only after spending nearly 2 hours sitting in the parking lot across from her townhouse. Every light inside was on. People she had never met carried boxes through the front door. One of them laughed as they arranged furniture in what used to be Daniel's workshop. Sarah looked away. She wasn't angry yet. She was confused. Nothing about the last 24 hours made sense. The next morning, she drove to the leasing office of Coleman Property Group. The receptionist recognized her immediately. "I'm sorry," she said quietly. "Mr. Coleman isn't available. I only need 5 minutes. He instructed us not to discuss your file." "My file?" The receptionist lowered her voice. "That's all I can say." Sarah slid a copy of the supposed eviction order across the counter. "Can you at least tell me where this came from?" The receptionist glanced at it. Her expression changed. For a brief second, she looked genuinely surprised. Before she could speak, a man in a gray suit stepped out of a hallway. Richard Coleman, mid-50s, perfectly pressed shirt, expensive watch. He didn't invite Sarah into his office. He remained standing. "You've already been evicted," he said. "The court decided." "I never went to court. You must have ignored the notices." "I never received any." Richard shrugged. "That's not my responsibility." Sarah held up the document. "What court?" "The Franklin County Municipal Court." "When?" "It's all right there." He turned and walked away before she could ask another question. That afternoon, Sarah drove directly to the Franklin County Municipal Courthouse. The security officer pointed her toward the clerk of court's office. A woman behind the counter smiled politely. "How can I help you?" Sarah unfolded the eviction order. "I need a copy of my case file." The clerk typed Sarah's name into the computer. Nothing appeared. She tried the property address. Still nothing. Then she entered the case number printed on the order. She frowned. "That can't be right." Sarah's heart sank. "What is it?" The clerk turned her monitor slightly. "This case number belongs to a traffic citation from 3 years ago." Sarah stared at the screen. "A traffic ticket?" "Yes. There has never been an eviction filed under your name." For several long seconds, neither of them spoke. Finally, the clerk looked back at the paper. "May I see that document again?" She studied the seal, the judge's signature, the filing stamp. Something wasn't right. "This doesn't look like one of ours." Sarah felt the room become strangely quiet. If there wasn't a case, then no judge could have signed this. The clerk nodded slowly. "I think you need to speak with an attorney." Sarah walked back to her car, carrying nothing except the folded paper. 24 hours earlier, she believed she had somehow lost her home through a legal process she didn't understand. Now she knew something even more unsettling. There might never have been a legal process at all. That evening, she began gathering every document she owned. The blue accordion folder, labeled home, sat on the kitchen table at her friend's apartment. Inside were 7 years of records, lease agreements, electronic rent confirmations, utility bills, maintenance requests, emails, even handwritten notes from repair appointments. She arranged everything by date. One receipt caught her attention. 3 weeks earlier, her September rent payment had been accepted automatically. The transaction showed completed. No diversid, no late fee, no warning. She printed another copy from her bank, then another. If anyone claimed she had failed to pay rent, the records would say otherwise. The next morning, Sarah returned to the courthouse. This time, she requested certified copies showing that no eviction action had ever been filed against her. The clerk prepared an official search certificate. She stamped it, signed it, placed the county seal across the bottom. Sarah held the document carefully. It was the first piece of evidence that proved she hadn't imagined any of this. But when she returned to Maple Ridge Lane, another surprise was waiting. A large moving truck stood outside her townhouse. Workers carried furniture toward the curb. Not hers. The new tenants were leaving. One of the movers shook his head. They moved in yesterday. So why are they leaving? They were told there were legal issues. Sarah thanked him. As she turned away, the young man who had opened the door the night before hurried after her. "Mom." She stopped. "I'm really sorry. You don't have anything to apologize for." He hesitated. "When we signed the lease, your furniture was still inside." Sarah's eyes widened. "What?" "The landlord told us everything would be cleared before we arrived." "What happened to it?" "I don't know. He hired a storage company." "Did you see the company name?" The young man thought for a moment. There was a white truck. No logo. No business name. Just plain white. Sarah felt a chill. Furniture could be replaced. Televisions could be replaced. Even clothes. But Daniel's handwritten journals, their wedding photographs, the wooden jewelry box he carved the winter before he became ill, those couldn't. That afternoon, Sarah began calling every storage facility within 30 miles. One after another gave the same answer. No record under your name. No record under the property address. No delivery from Coleman Property Group. By sunset, she still had no idea where everything she owned had gone. And for the first time since this ordeal began, she wondered if recovering her home might be easier than recovering the life that had been inside it. Sarah spent the weekend calling attorneys. Some sympathized but declined. Others explained that landlord-tenant disputes could become expensive, especially when property had already been re-rented. One lawyer listened for less than 5 minutes before saying, "I'm sorry, but this sounds like a misunderstanding." It was the fifth rejection in 3 days. Then Monday afternoon, someone gave her another name. Emily Carter, a civil litigation attorney in downtown Columbus. She had spent nearly 20 years handling housing disputes and document fraud cases. When Sarah arrived, Emily didn't interrupt. She simply listened. The lease, the rent increase, the locked door, the fake court order, the courthouse search, the missing belongings. When Sarah finished, Emily reached for the eviction order. She studied it in silence. Then she walked to a bookshelf and pulled out a binder containing genuine court documents from previous cases. She placed one beside Sarah's paper. "Look here," Emily said. Sarah leaned forward. "The county seal?" Emily nodded. "The color is slightly different." She pointed again. "The judge's signature is in the wrong position." Another page. "The filing stamp uses a different font." Sarah hadn't noticed any of it. To her, both documents looked almost identical. Emily closed the binder. "I've seen forged checks. I've seen forged deeds. I've even seen forged wills. But I've never seen someone fabricate an entire eviction order." Sarah swallowed. "So, I'm not imagining this." Emily looked directly at her. "No, I believe someone created this document. And if they did, this case is no longer just about wrongful eviction." Over the next 2 weeks, Emily's office began collecting evidence. Every rent payment, every email, every text message, the original lease, utility records proving Sarah had continuously occupied the townhouse, certified confirmation from the clerk of court that no eviction case had ever existed. Then Emily requested something unusual: the complete digital metadata from the email in which Richard Coleman demanded the higher rent. It revealed the message had been created on the same office computer that later generated a PDF attachment containing the supposed eviction order. The timestamps were only 12 days apart. That alone wasn't proof, but it was enough to justify further discovery. Then came another breakthrough. A forensic document examiner enlarged the eviction order nearly 20 times. Under magnification, tiny imperfections became visible. The court seal wasn't embossed. It had been printed. The judge's signature wasn't written. It was a scanned image copied from an unrelated public filing. Even the clerk's initials had been duplicated pixel for pixel. The document hadn't been issued by the court. It had been assembled, one layer at a time. Just when the case finally seemed to be moving forward, another setback arrived. Emily filed an emergency motion asking the court to order the immediate return of Sarah's belongings. Richard's attorney responded with a single sentence: "They cannot be returned because they have already been disposed of." Sarah read the filing twice. Disposed of. That one word hurt more than losing the townhouse. Daniel's journals, their wedding album, the letters he wrote during chemotherapy, the cedar jewelry box, the quilt Sarah's mother had sewn before she passed away. Gone. No inventory. No photographs. No explanation. Sarah quietly folded the paper. Emily didn't rush to speak. Finally, Sarah asked, "What if I never get any of it back?" Emily answered honestly, "You may not." The room fell silent. Then Emily slid another folder across the conference table. "If they destroyed your property without lawful authority, that becomes part of the case too." Sarah nodded slowly. For the first time since she had stood in the rain outside her own front door, she wasn't thinking only about what she had lost. She was thinking about proving exactly how it had happened. 6 months after Sarah found the new locks on her door, the courtroom was finally full. Neighbors, former tenants, court staff, reporters from 2 local newspapers. What had started as a routine housing dispute had become something much larger. Because the central question was no longer whether Sarah had been evicted. It was whether someone had forged the authority of the court itself. The judge adjusted her glasses and looked toward counsel. "Call your first witness." The trial had begun. The courtroom was quiet enough to hear pages turning. Sarah sat beside Emily Carter at the plaintiff's table. She had imagined this moment hundreds of times. None of those imagined versions felt as ordinary as the real one. No dramatic speeches. No shouting. Just a judge, 12 rows of wooden benches, a court reporter, and 2 attorneys preparing to present evidence. Emily stood. The plaintiff calls Melissa Grant. Melissa Grant, the deputy clerk from the Franklin County Municipal Court, walked to the witness stand and took the oath. Emily handed her the document Sarah had found taped to her front door. "Ms. Grant, do you recognize this document?" "I recognize what it is intended to look like." "What do you mean by that?" "It resembles one of our eviction orders." "Did your office issue it?" Melissa answered without hesitation. "No." Emily paused. "How can you be certain?" Melissa pointed toward the heading. "The case number belongs to a traffic citation from 2016. She pointed again. "The court seal is printed incorrectly." Another line. "The filing stamp does not match the stamp used by our office." Finally, she indicated the signature at the bottom. The judge whose name appears here was not assigned eviction cases on the date shown. The courtroom remained silent. Emily looked toward the judge. No further questions. Richard Coleman's attorney stood for cross-examination. "Is it possible this is simply an administrative error?" Melissa shook her head. "No." "Could someone in your office have misplaced the file?" "No." "Why not?" "Because no file ever existed." Emily's next witness was the forensic document examiner. Large digital enlargements appeared on a courtroom monitor. He compared Sarah's document with authentic court records. The differences were impossible to ignore. The signature is a scanned image. The seal was copied from a publicly available PDF. The filing stamp was digitally recreated. He zoomed in further. Tiny square pixels surrounded the signature. The document was assembled electronically. He looked toward the judge. "In my professional opinion, this is not an authentic court order." Richard Coleman testified that afternoon. He insisted he believed the paperwork was legitimate. Emily approached with a stack of exhibits. "Mr. Coleman, who prepared this eviction order?" "My office handled the paperwork." "Did you verify that a judge had signed it?" "I assumed everything had been processed." Emily picked up another document. "This is an email from your property manager." She read aloud. "No eviction has been filed yet. Should we wait?" Emily looked up. "You replied 6 minutes later." Another page. "No. Change the locks this weekend." Richard shifted in his chair. Emily continued. "By that point, no court case existed." He didn't answer. "Mr. Coleman, yes or no?" "No." "And yet your maintenance crew changed the locks." "Yes." "You rented the townhouse to another family." "Yes." "You removed Ms. Mitchell's belongings." "Yes." Emily picked up one final exhibit. A contractor's invoice. Date, September 14th. Description: replace front and back locks. Unit 214. Time completed, 9:42 a.m. Sarah had been speaking at a teacher's conference nearly 200 miles away at that exact time. Emily placed the invoice on the evidence table. No further questions. The judge requested a brief recess. When court resumed 30 minutes later, everyone returned to their seats. She adjusted her glasses and began reading from her written findings. The evidence establishes that no lawful eviction proceeding was ever initiated. She turned another page. The document presented to the plaintiff was fabricated. Another page. The defendant relied upon that fabricated document to remove the plaintiff from her residence without legal authority. She looked directly toward Richard Coleman. "This court finds for the plaintiff." The judge ordered immediate restoration of Sarah's tenancy rights, compensation for destroyed and missing personal property, reimbursement of temporary housing expenses, lost wages related to the unlawful eviction, attorney's fees, and court costs. Then she added one final sentence. This matter shall be referred to the appropriate authorities for review of potential criminal offenses involving forged judicial documents. No one spoke. Sarah closed her eyes for a moment. Not because she had won, because, after months of uncertainty, someone had finally stated the truth aloud in a courtroom. 9 months later, the townhouse looked different. Fresh paint covered the front porch. New flower pots lined the walkway. Sarah had planted white daisies beneath the living room window, just as Daniel always had each spring. Some things never returned. The journals were gone. The wedding album was never found. A few family photographs survived only because friends had digital copies. One Saturday morning, Sarah carried a small wooden frame into the living room. Inside was a picture of her and Daniel standing on that same porch years earlier. She placed it on the bookshelf and stepped back. Sunlight filled the room. Outside, children rode bicycles down Maple Ridge Lane. Life had moved forward, quietly, steadily. The house no longer represented what had been taken from her. It represented what had been restored. Sometimes justice doesn't erase a loss. It simply makes sure the truth has a place to live.